Hello, my name is Natalia Porsche and I'm an immigration attorney here in the United States. And in this video, I will speak about cancellation of removal. It's 42A. We have two kinds of cancellation of removal under immigration law of the United States. First cancellation of removal, it's for LPR, for legal permanent residents, and it's 42B cancellation of removal, 42B form. And we have a cancellation of removal for people who have been here, undocumented immigrants, and they will qualify to file form 42A. 42A, it's a cancellation of removal for non-LPR, for non-legal permanent residents. Okay, again, to remind you that people, in order to qualify for this remedy for cancellation of removal under 42A, if you are not a legal permanent resident and you ended up in deportation proceeding, the only time this remedy is available to a person, to undocumented person, a person without status, it's when that person ends up in deportation proceeding. Otherwise, this remedy, unfortunately, is not available. As for example, application for asylum, you can file that application 589 form, I-589, even if you are not in deportation proceeding. That way, that application will be offensive application rather than defensive when you are in deportation proceeding with immigration court. So now, like I said, this 42A form is only available to those undocumented immigrants who are in deportation proceeding. That's number one. Number two, those people, undocumented people, they must be present in the United States for at least 10 years before they've been served an NTA by the government, right? So NTA, it's a notice to appear. To appear, it's a formal document which cuts off a date for this 10 years. It's put a stop on a clock, right, running this 10 years. So what is the important thing to know about this? The important thing to know about this, and this is a law that we have a case that was issued by Supreme Court of United States, and that case says that if your NTA, notice to appear, does not have a proper date or a time, not an a time, right? A proper date or a time when you are supposed to appear in your immigration removal proceedings in front of an immigration judge, that means that NTA is defective NTA, and that NTA does not cut off that running, does not stop the clock, right? So that 10 years doesn't stop running. Let's say we have an example when this person was undocumented and been in the United States for a while now, and let's say 5 years after he entered the United States here illegally, that person, let's say, was served an NTA, notice to appear, but that NTA did not have a date and time, right, where this person supposed to appear. Let's say that NTA stated that the place and time to be determined. Well, guess what? The Supreme Court of the United States held that this is a legal NTA, that it doesn't stop the clock ticking on that 10 years timeline. Therefore, let's say if this person failed to appear for a reason that he did not know he had a hearing, and he did not enter his appearance, he did not have his counsel enter his appearance, and we have an order of removal. Well, guess what? That order of removal in absentia is also not sufficient order, which can be, this case could be reopened, right? If that person ends up again in deportation proceeding, we can argue that no, this deportation order is not valid because that's, first of all, in absentia. Second of all, that deportation order was issued based on a document, NTA, that was issued by the government, which is illegal document. It's insufficient document to prove the ground of removability, right? Because it didn't have a proper date or time. Therefore, that person, if when he already or she been served the sufficient NTA with proper date and time, he or she can apply for cancellation of removal, arguing that no, I am eligible under this recent case. Supreme Court of the United States held that my NTA was deficient. Therefore, I'm eligible to apply for cancellation of removal under 42 and file the form 42A. It's a cancellation of removal for non-LPR. Now, burden number 3, what this person needs to, the respondent, let's call this person a respondent in deportation proceeding, what this respondent has to show in order to receive this form of relief, a cancellation of removal. That person must show that, first of all, 10 years, we already spoke about that, and then that his or her removal from the United States will result in a hardship. It's a hardship to a qualifying relative, and qualifying relative can be United States citizen or LPR, legal permanent resident. It can be child, spouse, or a parent, right? And this is very, very important to know that also children, they're not just biological children to whom the hardship will result. Also, the law considers stepchildren and adopted children. Okay, so let's say if people are married, but this is not a biological child, then under the law this child will be treated as this respondent's person's child, right? Therefore, that's a very positive thing, right? So if you don't have just biological children, you can argue that your removal will result in a hardship to your stepchild or adopted child. Also, a lot of people, a lot of practitioners, they are under the impression that a lot of people are under the impression that their hardship must be shown by a serious medical condition, right? So they must have a serious medical condition, therefore that's a hardship. That's incorrect. There are a lot of different factors, and it's in very, very not a lot of cases that those are cases which can establish the hardship per serious medical condition, right? That let's say when the person is removed to a country where they don't have a proper medical care for that condition, therefore it's a hardship. Well, not just that, it's a one good factor, but the totality of factors will play a role here, right? Let's say if you suffer a stroke before, and that will result in your spouse, your citizen spouse, moving with you back to, let's say, Honduras, and Honduras don't have a medical care, so that hardship will be also upon your citizen spouse. Why? Because the citizen spouse will have to give up a job here. The citizen spouse, let's say, will not be able to locate proper housing over there, proper job over there. So how that citizen spouse supposed to support you while you're going through medical treatment, or you have a cancer or any other sort of condition, not just medical condition, also for example, if you can show to the judge that, look, judge, this is the house where my family will be living, my U.S. citizen spouse or LPR will be living in Honduras, and you can show the picture of the house and it looks awful. And obviously you try to locate jobs, but there are no jobs for you for the job that you have. So therefore there is no job. So how are you supposed to provide for yourself and your family, and your spouse is not able to work, let's say? Of course you cannot. Also, the hardship could be established through children, right? Let's say children will have to relocate to Honduras. And in Honduras, there is insufficient education, right? Or to relocate to any other country where we have insufficient education, where parties will have to pay for private schooling. Okay, we'll have an issue again. So if the person doesn't have a job, how are they supposed to pay for private schooling, right? How are they supposed to pay for food? How are they supposed to transport their children to extracurriculum activities, which, guess what, not available, let's say, in their country of origin. So there are different hardship factors. And again, the totality of factors will play a role here. So you cannot just take one factor and say, hey, there is no medical hardship, therefore let's just say that there is no hardship. Well, that's not how it works. That's not how law works. You have to develop a story. You have to tell a story. What is going to happen if your spouse, not you, but the hardship to your spouse can be through you again, right? Because it's your spouse. You have a life together here, right? So if your spouse have to change a life and move to Honduras, to country where she or he never been before, so guess what's gonna happen? This person is gonna go through hardship, because this person who never spoke Spanish in her life will have to find a job over there. So how that's gonna happen? So there are different factors that will play into consideration here. That's why you need to contact an experienced attorney, because the attorney will help you to create that story, that factors, develop the story based on those factors that will help you to win your case. Again, this is a difficult remedy, right? This is a difficult remedy to prove. A burden of proof is on the respondent. Like, for example, we have a cancellation of LPR, which is 42B application, right? Well, that's a little different, because the burden is on the government to show that this person is removable by clear and convincing, right, evidence. However, this is a burden on you, on the respondent, to establish that you qualify for that cancellation of removal, form 42A, under 42A, and its burden is on you, not on the government. And also I wanted to speak about the criminal. Little traffic violations can make you ineligible for this remedy. Why? Because you must show, first of all, that you're great, you possess a good moral character. So any traffic tickets, no driver's license, speeding, you have to be very careful with those. Because that can show that you are not a great moral character. Therefore, it's one of the factors also that you bear a burden to establish here in the United States to qualify for that cancellation of removal for non-LPRs under 42A. I hope this video was helpful. If you are interested in if you're in deportation proceeding, and if you're interested in speaking with an experienced deportation or immigration attorney, you can call my office. Phone numbers down below, 228-229-7500. Set up a consultation. Again, very important to speak with an experienced immigration attorney about your NTA. So the attorney, if you have a prior order of removal, attorney can do a legal research and see what exactly was ordered by immigration judge in your previous deportation proceeding, whether it can be under where we can undo it and apply for cancellation of removal, because a lot of people who've been here for a while not eligible for asylum because of 1 year deadline. 1 year deadline passes, you have to establish a good cause why you didn't file for asylum, and immigration judge is they're very strict about that, right? So again, thank you for listening. Thank you for watching this video, guys. I like your reviews. I like your views. I like every time when you like my video. If you're interested, sign up for my channel, and thank you for watching again. Goodbye.